Welcome to the Second Dean's Town Hall of 2015-16. Hard to believe that we're already there at the end of January. As you may be aware, one of the commitments I made during the market modifier discussions a year ago fall was in response to student concerns that there hadn't been enough interaction with the dean. I was new and I said, not a problem. I may have gone too much in the opposite direction for some people's liking, but and shown up everywhere, more than sometimes you expect. But at least having two town halls anchors that commitment and permits us as a faculty community to have a discussion about things that are important. I remind you that when we get to the point of Q&A as well, that there are microphones. Would ask you to speak into a mic. The session's being recorded and will be uploaded to the website, so know that you may go viral in that respect as well. Just, and again, for purposes of identification for the video and for your community. If you do the favor of identifying yourself when you're at a microphone, that would help. President of the Law Society, as I mentioned, is going to be joining us, and as announced, I'll be turning over the meeting to actually Dharam Dhillon, the LSA, and the President of the Law Society to discuss the proposal by the Federation of Law Societies National Admissions Standards Project Steering Committee for a new approach to transition and qualification for entry into the legal profession. This is really a discussion that students need to have with the regulators directly. That's already happened, I understand, at both UBC and UVic. I wanted to make sure that we had an opportunity to have that exchange, to make sure that the information that was flowing was accurate and complete, and that people had the opportunity, and that you in particular had the opportunity to tell the Law Society or speak to the Law Society directly about some of your concerns. So I'm glad to be able to facilitate that. It looks as though actually Mr. Eamon has just arrived. So welcome to the President of the Law Society of Alberta, Jim Eamon. Thank you very much for joining us. I'm just doing a bit of an introduction, everybody. As I'll discuss later on, I had actually signed a letter together with all of the Canadian law deans in November expressing some of the concerns about the proposal. I'll come back to that later on when I turn over the session to Dharam and to Jim. But before we get to all of that, let me say welcome. Thanks for coming. As with last year, I want really this session to be a bit of an update about what's going on within the faculty, within the university, and to afford an opportunity separate from Law Faculty Council to address some pressing issues. I've held similar meetings with staff separately and faculty separately in the last week, which I think is meaningful and important, and so this comes after those discussions but will be an important supplement, and I'll circle back with the faculty, many of whom are here, about some of these concerns. The last year has been a remarkable period of challenge and change, and I appreciate in particular the energy and effort that all of you have expended to continue to help us create and foster a supportive environment for students, for the faculty, and for the communities we serve. The work that you're doing is really important in moving us forward, and being willing to pick up the shovels where necessary, to accommodate, to be patient, is really helpful as we really turn things around in a very positive direction. When I met with staff last week, our new Assistant Dean Administration, Robert Bechtel, reminded me that all but 6 of the staff were new to the faculty within the past 12 months. That's a remarkable turnover, and our new staff members, many of whom are here today, are already making a real difference. There's some strains, some challenges. We're working to smooth things out, and they will get better. But I encourage you to, if you haven't met a staff member, say hello, introduce yourself. Make sure you find out who they are, where they've come from, what they're doing. You find out the stories that are really quite remarkable. Aileen Riley, for example, I managed to actually meet on stage at Convocation last November, and she was profiled university-wide for the research work she'd done on her master's with Aboriginal communities. I mean, our staff members are bringing extraordinary stories, like many of you as well, so get to know them. Please understand as well that, as I've said to staff, quote, "This is the way we've always done this," is guidance, not gospel. We're trying to introduce new processes and new ways of doing things. We're certainly open to your suggestions as well as to how we can improve. I thanked all of the staff, but offered particular thanks to Hillary, Aileen, and Yvonne for their efforts during the exam period in December. It's perhaps one of the most stressful times of years, not only for students, but for staff as well, and for faculty. This was a first go for all of the staff through that period, and none of them had been here through a prior exam period at Christmas time. They did remarkably, remarkably well. And always, of course, and I don't think he's here, but we'll do the shout out in any event, Tim Young's unfailing calm and care with technical issues remains of critical importance for all of you, for staff, all of us. I expressed our thanks to Tim. I had actually nominated Tim last spring for one of the internal faculty, or one of the internal university awards for basically client service in IT. I'm going to need your help this year. I want to make sure he gets it and gets recognized appropriately because that hasn't happened yet, and it's absolutely critical that we acknowledge and appreciate what he does for us. If you haven't seen as well, I expressed our thanks to him and offered congratulations for his recent media coverage. Again, one of the things that you'll find out if you start talking to staff is that they have remarkable talents. You have probably seen him passing you in the hallway more quickly than other people would pass you. There's a good reason for that, given his success in North American stair climbing championships. A star has been born. We know a few lawyers, so we can get him an agent when he's ready. One of the things that I'm really appreciative of Tim for as well, though, if you heard some of his media interviews, he was really grateful to this faculty, to the faculty, to the staff, the students especially, for making this a place where everybody can be their best. Quirky, idiosyncratic, doing interesting and different things. That's the kind of community we are, and really, really proud to support it. So congratulations again to Tim. I like to focus on awards and accomplishments. I've got one more that I want to recognize before moving on to two sets of honors for students. Professor Mitch McInnes, as you may or may not be aware, was named recipient of the Distinguished Service Award for Scholarship awarded jointly by the Law Society of Alberta and the Canadian Bar Association Alberta branch. It's a wonderful, wonderful honor for Mitch personally, and by extension for the faculty and all of you. As a committed teacher, as a scholar, it's wonderful recognition of his career contributions. I'm looking forward to being at the luncheon at which he'll be presented at the Alberta Law Conference on Friday, so congratulations to Professor McInnes. For our students, two sets of honors, and I actually want to call up, if I might, the Miss Magna Carta team. So Kate Andrus, Nicole Watt, Kathleen O'Driscoll, Vanessa Corzan, and Sarah McCourt. I don't know how much you followed what they've done, but this is quite extraordinary in terms of what attention has been brought and the kind of success that they've had with respect to the Miss Magna Carta project. This has been a wonderful opportunity for our faculty and for the university to be profiled. The project that they undertook for a year in law and social media, and by extension otherwise, with interviews from everybody, including me, to hip-hop artists, to others, has gotten attention around the world. And in Parliament got recognized. A reception held here at the legislature in November was the culmination of a year of Magna Carta events organized out of Toronto. And we're very proud to have sent to the faculty, and I want to take a moment just to read a letter from the Magna Carta Canada 2015 director, Art Linton. Dean Payton, I'm writing to thank you for the important support provided by the University of Alberta Law School faculty, students, and staff during Canada's commemoration of the 800th anniversary of the Magna Carta. The event brought Canadians together from every corner of the country to engage with their legal heritage and through that to better appreciate Canada's system of justice. The 2015 Magna Carta Tour provided focus for that experience. Our legal community provided leadership and a unified voice. Canadians looked to the legal community for leadership. In addition to your support for the law student essay competition, members of the university legal community attended events with the Honourable Peter MacKay, Minister of Justice and Attorney General of Canada, as he then was, the Right Honourable Beverly McLaughlin, the PC, Chief Justice of Canada, the Judge Advocate General, the Canadian Secretary to the Queen, and the British Consul General. The youth of Canada has been an attentive and important audience throughout the year. Magna Carta classroom materials have been distributed in English and French to tens of thousands of teachers in every province and territory in Canada. Every law school in Canada participated in a Magna Carta law student essay competition with generous prizes provided by the law societies. This commemoration has reflected well on our legal community. Please accept the accompanying certificate of appreciation in recognition of your support Separately, he wrote to me to pay tribute to the team who did such a wonderful job not only at the event in November, but throughout the year in terms of bringing attention that frankly nobody else was doing. So this is going to have pride of place upstairs on the 4th floor. And in addition, I had an opportunity when I was across for the American Bar Association London sessions, which was actually held in tribute to the 800th anniversary of the Magna Carta, to stop by the British Library exhibit. And so for each one of you, I have a matted copy, and we can get them framed if you'd like, of the original copy that was on display through the summertime. So a lot of script that you won't be able to read, but hopefully a commemoration of the work that you've done. Thank you on behalf of the faculty for all of your efforts and to bringing such pride to us, to the university, and to the legal community. Congratulations. 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 Well done. Thank you. Thanks very much. One other acknowledgement, and this is actually a work in progress. And again, I think one of the things that has been really important that I've tried to emphasize in this period of renewal and growth is things that are unique to the law school experience. Mooting, SLS are two of them. Law Review is the third. And many of you have taken that to heart and have really contributed. And I encouraged everybody to do at least one, ideally two, of those things, in addition to law show and sports and everything else that you're involved with. Well, one of the things that's actually really heartening is the kind of success that students who have been on this year's editorial board of Law Review have achieved in securing placements for clerkships. And I've got a partial list. I know that the list is still being formulated and there are still a few out there, but let me recognize and congratulate, and I think my list is accurate. I apologize if it's not, and if you're not on here yet, we'll make sure that you get added. Congratulations to those who have secured clerkships at the Court of Appeal in Calgary: Sunny Mann, Ashton Manuz, and Caitlin Field. I don't know whether any of you are here. In Edmonton, Brandon Rogerson. Brandon, congratulations. With the Court of Queen's Bench in Calgary, Matthew Schneider, Matthew Summers. In Edmonton, Brooklyn Leclerc, Lauren Chalaturnik, and Adam Chimbrowski. So congratulations to all of you. Well done. I think the other thing that's really important is that from generation to generation of clerks, there is a tremendous body of knowledge about how best to prepare, how best to interview. The faculty remain available for you in that respect, and I remain available as well to help, encourage, and support anybody who's wanting to actually try for a clerkship at any level. And so in that respect, at least, those of you who have managed to secure clerkships, you now have a responsibility to pay it forward, and we'll look to you for that kind of guidance and support, along with everybody else, to make sure that the U of A Faculty of Law continues that outstanding record of representation. To the Alberta Law Review, congratulations to your editorial board and to a team. It's tremendous, tremendous recognition of the work that you do. Okay, a few updates on various things before I turn the meeting over with respect to the Law Society and the LSA discussion. Few things that I wanted to cover very quickly, and then I'll take some questions. Faculty hiring. As you're likely aware, we've just finished a very long round of candidate interviews for faculty positions. I remain very grateful to the Advisory Selection Committee and indeed to the faculty for their attention, participation, and feedback. This has been quite the process, but a really exciting one for the faculty. Jodica Kaler was the student representative on the committee, and I'm grateful for her work in ensuring that the student perspective remained front and center in what's both a confidential and critically important process for the future of the faculty. You'll recall that last year during the market modifier discussions, there was not only the up-down vote on whether or not to increase tuition, which ultimately passed but then was rolled back, but also on individual components. And the number one priority from students that we've tried to take forward is hiring new faculty. My goal has been to hire up to 9 faculty over the next 3 years. This is a time of replenishment and renewal, and we've had outstanding candidates. We received over 60 applications for 3 positions. By last count, 43 men, 19 women applied, 29 from Canada, 12 from the US, 4 from the UK, and others from a wide range of other countries. The committee recommended, and we interviewed 10 candidates in the regular stream, 5 men and 5 women. I met with the committee. I have their recommendations and feedback from the faculty and from Jodica on behalf of the students, and I'm working on finalizing some decisions. I'm looking forward to making those announcements. As you can appreciate, processes of negotiation take a little while and are very confidential and very sensitive. So in that respect, at least, I will make announcements as soon as I possibly can. Having additional faculty will respond to one of the issues that I know has been a concern, which is course availability. I'll come back to talking about that. The whole process was remarkable given our late start. Given budget uncertainties, I wasn't able to proceed with advertising until I had a meeting with the provost at the end of September, and having his assurances that we could proceed with confidence, even given provincial budget uncertainties. And so in that respect, we're well set for next year's hire, and so far at least, despite some uncertainties and some concerns about what will come forward in the provincial budget, we're poised to continue. One of the other things I announced to faculty at the beginning of January was that I managed to secure additional support and funding from the provost for two-year visiting assistant professorship positions, one of which specifically is designated subject matter area for Aboriginal Indigenous. It's very important as an incubator for the faculty. I'll be looking to hire into both of those positions on top of the 3 that were already advertised. And so in that respect, at least, you're going to see a lot of new faces around the faculty at the front of the classroom. It's a very, very exciting time, and that process will continue. Later this spring, I'm going to be meeting with the Advisory Selection Committee again to talk about some priorities for next year. I also plan to meet with the LSA executive to get their feedback on these plans as well. Oh, Jodica, sorry, I didn't see you there. Thank you very much indeed. Wave to everybody. Thank you very much for your contributions, more meetings, more hours spent in meetings, more time spent reviewing candidates. That kind of care and attention was tremendous, and tremendous representation on behalf of everybody here. A couple of other things going on behind the scenes. Faculty staffing, in addition to hiring Mandy last summer as a second career services officer. We've brought in Kamal Kumar, who I'm sure many of you have already met, as our student services coordinator to be frontline support for student groups and to dedicate a particular portion of her time for our Aboriginal Indigenous students. This is a start. It's not a solution. And I'm looking at that entire portfolio and seeing what more we can do and how we can do it better. So thank you very much for joining us. Welcome aboard. Please get to know her, and I think in terms of dealing with the student groups, we'll try and continue to replenish that portfolio. In addition to the faculty candidate process, I've also been involved in a search and interviews for a Director of Communications. Amazingly enough, since I arrived, since a year ago, September, if you're paying close attention to the website, I've been congratulating the Law Review on its new premises for over a year. We've got some work to do on the website and on communications. I've done some interviews for a Director of Communications, looking forward to making an announcement hopefully in the next few weeks. In addition, I'm looking this spring to hire, and we're in the process right now of looking at a recruitment and financial aid officer. One of the things that students have told me increasingly is that notwithstanding the support they get from the student services team and from Heather as our new admissions officer, I guess we can still call you that, from last January, more students are wanting additional assistance both as they're applying to law school, but also when they're here with financial aid, and we want to make sure there's more dedicated support. And so I'm looking to enhance that portfolio as well. Lots of other things going on in terms of I've rebuilt and reconstrued our external advisory boards, Calgary, Edmonton, Vancouver, Toronto. Some recent grads as well as more seasoned ones. I'm going to try and get them here. They're all passionately involved and caring and committed to the success of this faculty. It's great to have them. I've ensured in terms of representation on the boards that we've got gender balance, that we've got diversity both in terms of years of experience and also in terms of ethnic and other diversity. The other part of the equation that I think is important is that it's representative of a new profession. So there are major firms represented, but small firms, non-traditional practices, some retired lawyers as well. People have taken different paths. All of them are providing advice. I've said I need 2 things from them: advice and advocacy. I'm hoping the dollars will follow, because development and fundraising is a big part of what I'm trying to do. But will it get their perspective on where you need to be going? And it's going to be helpful as well as we talk about an increasingly constrained job environment, that they remain a network that I am absolutely prepared to contact, and they're prepared to help for those of you who have difficulty securing positions. So that's one thing I want to turn to right now. I know that the job environment is worrisome to many, and I've been getting regular updates from Mandy and Pat in Career Services about placements. We're doing well. We're doing very well in a constrained environment. We are well ahead of what national placement rates are, but that doesn't really matter to those of you who are still looking for a position. And so in that respect, I think one of the things that we're focused on is not only how can we improve career services better, doubling the complement, making sure we put you in touch with opportunities, but also to make sure that we get additional opportunities. The Law Society's move to modernize, or at least get a little more creative with the ability to do what I'm probably calling incorrectly composite articles, or working with different lawyers, different employers over the year, will, I think, help those sole practitioners who might be willing to take somebody on for 3 or 4 months, but not an entire term. And it may mean that you need to get more creative in your strategies about geographically, where are you prepared to go? What does the 12 months look like, in addition to traditional articles? We've been through economic downturns before. I graduated myself into a recession where 2 friends of mine had actually articling offers collapse from major firms when the firms collapsed. And they had to put together and get creative about their approaches. We'll get through it. And you've got my support. I've already talked to the Alumni and Friends group to say, when I need to pull the lever, I will be counting on them to help you land jobs. But you also have to do the work. Make sure that you're prepared. Take advantage of the opportunity that you have for career services counseling. Get creative in terms of the search. And if there's something that doesn't look necessarily like it's exactly what you want, consider whether or not it provides the opportunity and an open door for later on. And so in that respect, at least, you can also turn to your upper year peers for advice, for support, for direction. But I think what's really important is to know that we're dedicating the resources for it. We want to make sure that you succeed with the help of a broader U of A Faculty of Law community. We will make sure that we do the best thing possible to help you succeed in that respect, whatever the economic conditions end up turning out to be. Believe you me, when I arrived in July 2014, the Canadian dollar was at 95 cents. Oil was at about $100 a barrel. If I was an economic forecaster, I'd be out of a job. But in looking at the ways in which the legal profession is changing and the way in which firms are responding, I'm in their offices, not only to try and raise dollars for the faculty, but most importantly right now, to say, you need to hire our students. You need to make sure that the articling pipeline, forgive the expression, remains open. And so I know that's a continuing concern. There is some question about government budget uncertainty. I only know what I know right now, and we are optimistic, cautiously optimistic. I know that the university is in continuing dialogue with government. I will let you know about any potential impacts, believe you me, as soon as I know anything. But right now we're on course. This government basically has done what they said they were going to do with us in terms of continuing and supporting our funding. That is allowing us to hire, and I'm hoping as well it will respond, working with the Vice Dean, to some of the concerns about the number of sessional instructors we had to cut back and the number of course offerings that, because of budget uncertainties, had to be reduced. When it came to May and June this past year, we honestly did not know what we were working with in that regard. And that forced some very difficult decisions and some rationalization that may have been overdue in some respects, but overdone in others. And as we've been able to add on for this term and otherwise, we're trying to replenish. So it's a fine balance. We're doing the best we can, and I think bringing in the new faculty creates an exciting opportunity for more core courses taught by core faculty who are tenure stream, but also replenishing those who are actually sessionals or otherwise supplementing our teaching. Lots of other meetings I can talk about, but I'm conscious of the time for the president of the Law Student Association and the president of the Law Society. But before I kind of close off, wondering if, how are we doing on time? I'll take about 5 minutes of questions right now if there are any, and then I'll also come up at the end and be available for questions following the session, but I do want to turn things over. Any questions immediately, and you can feel free to email or pigeonhole me afterwards. On to the main event. Thank you very much indeed for your attention, for coming. And again, congratulations to the Miss Magna Carta team. Congratulations to Tim. Congratulations to those of you who have secured clerkships. It's a really exciting time. And I hope that for those of you who are in the 1L year this year, that energy that you brought in August to the welcome events and to orientation continues on through. You've now seen what one set of exams look like, but you can also now rest assured, you know the drill. Things will get better, and they can only get better from here. Get involved, stay involved, and be part of what is a terrific community that I'm really proud to serve as Dean. Many thanks.
That this project was moving along an extremely tight deadline, so any response needed to be prompt. We did our best to circulate this information to everyone. John Austin, our VP Academic, put together a very comprehensive summary of the proposal, which was sent to the student body along with the original proposal document. With this information, we conducted a survey that a strong contingent of the student body responded to. The survey asked 4 questions. Do you feel that Alberta's existing CPLED program is a satisfactory bar admission program? 90% of the student body said yes. Does the prospect of a national assessment regime worry you? 84% said yes. Should the Law Society of Alberta participate in the proposed national assessment regime? 86% said no. Should the LSA send a letter to the Law Society of Alberta? This letter would address the results of the survey and would communicate student concerns regarding the proposed national assessment regime. 97% said yes. As part of our consultation process, we reached out to other schools to see how they were reacting to this proposal. Some other schools who wrote to their respective law societies took an aggressive and firm stance against the proposal. Under the tight deadline for response and all this information in front of us, we as a group decided that the prudent thing to do would be to write a letter to the Law Society to ask both for more time and for more information. We did that by writing a letter to President Eamon on December 8, 2015. He was more than cooperative and agreed to come here today to address any lack of information or concerns that the students might have. And now with that, if there aren't any further questions, I'll pass it along to President Eamon.
Let me, if I might, just thank President Eamon for joining us today. I thought it was really important in terms of facilitating a dialogue between the LSA and the Law Society that there be the opportunity for this discussion and for this dialogue. It wouldn't happen without you being here, and we're really grateful to have you. Thank you very much indeed.
Thanks very much. 2 preliminary things. First, my apologies for being late. I tend to use the airplanes in the wintertime, and I'm at the mercy of the pilot. And secondly, nobody calls me President Eamon. Usually I go by Jim, and by the time I'm done presenting unpopular initiatives, you can have other names. So I'm here to speak to you about the National Assessment Program, and I'll hear your concerns about it. I'd rather say I'll hear your input about it, but either is fine. And I would point out that this should not be the last opportunity for input. I'm done in my presidency. In 8 days' time, I'll send a report on to the incoming president so they know where things are at, and I'll give you a little bit of an idea as to how things work at the Federation, and that might assist you in planning what you want to do in relation to the proposal. So this assessment proposal is the next step in what we call the National Admission Standards Project, and I need to give you some background to that project. I think as everybody knows here, the Law Society of Alberta is the regulator of the Alberta legal profession, and so we govern a number of different areas. We deal with qualification for admission. We run the bar admission course, or we have the authority to run it. We deal with conduct and discipline of lawyers and also students. We set the practice standards in this province. We set the ethical standards in this province. We also run insurance programs. to cover clients when lawyers act negligently, and we run assurance programs to cover clients when lawyers steal from them. So we have quite a wide range of business, and in everything that we do, we run across a very wide range of people. Sometimes we refer to them as customers, sometimes we refer to them as members. If they have enough dealings with them, we sometimes call them frequent flyers. And there's any number of issues that lawyers face all the time. We deal with lawyers who are incompetent, lawyers who weren't properly trained, lawyers who didn't get proper articles, lawyers who are stressed out, lawyers who are mentally ill, lawyers who are addicted. You name it, we deal with it. And in all of that, our purpose is to protect the public. But the way we look at it, if you're capable of remediation, we'd rather see you remediated than removed from the profession. And we have that attitude. It starts with students, and it runs through the career of lawyers. So we're not out to set people up for failure. We're actually we're interested in setting people up for success. The Federation of Law Societies of Canada is an association that consists of 15 members, and those members are the 15 legal regulators in Canada. Quebec has 2, by the way, and that's how we get to 15. And there's a certain reality in dealing with the Federation, and there are really 2 aspects to it. First of all, there's a need that's received a lot of recognition even since I was elected a bencher in late 2008, and that need is to pursue standards on a national basis across Canada, and I'll come to the reasons why that is. And the second is that in order to get along in a federation, just like the Canadian Federation, there's always some give or take in any of the initiatives to ensure that we reach a consensus. And everything that we do at the Federation is by way of consensus. We don't seek to impose initiatives on law societies if they're not willing to consent, and in those cases, 1 of 2 things will happen. One is the standard is changed until it is acceptable to everybody, or secondly, law societies have the option not to participate. The legal profession itself is always under scrutiny from many groups. We, as the regulators and the legal profession generally, are always conscious of inroads against the independent regulation of the profession. We see the regulation of the profession by lawyers and some members of the public appointed by government as key to what we do. At the end of the day, we have a very unique role in the administration of justice. We deal with client secrets. People need to be able to come to us and make a full disclosure of their affairs to us if they're going to receive proper legal advice, and people need proper legal advice within the Canadian legal system. And so things such as solicitor and client privilege and who gets to discipline a lawyer and those types of issues are always very important to us. In some overseas jurisdictions, independent regulation has been lost. In England, for example, solicitors are now regulated by a solicitor's regulatory authority, which has more of a consumer affairs type of approach to the regulation, and the members, as far as I'm aware, are appointed by the government. And that has happened in some other jurisdictions as well. We're careful on our side in Canada to ensure that the processes and the standards that we use evolve with the times, and that they represent current best standards, and that they're fair to people and they're defensible. And when I say fair, as I said earlier, we're not out to set people up to fail. We prefer to see a thriving legal profession with happy practitioners who will succeed. That's the best way to serve the public. And when I say defensible, I mean standards that represent current best practices and that we can objectively say by pointing to external information are practices that are in the public interest and ought to be the ones that are used. Now, over the last 30 years, there have been a number of changes to the way that we practice law, and with that has been changes to the expectations of how law societies, like any other regulatory board, have to run. And I'll give you an example, and that example engages directly what we're here today to talk about, and that's the practice of law and the scope. You know, in the mid-1980s, the Law Society of Alberta was concerned about the growth of so-called national law firms. They just started in 1982. What happened was the Charter of Rights and Freedoms came into force in April of that year, and law firms were interested in crossing boundaries. They were aware that there would be mobility rights in the Charter, there would be equality rights in the Charter, and so once the Charter was put into force, they began to open law firms across boundaries in the provinces. So the way they did it in Alberta was you'd get some law firm in usually Ontario that wanted to start a national law firm. They would recruit some people who were members of the Law Society of Alberta. They'd start a new law firm, and they gave it the name of the local partners because we used to regulate the names of law firms. And then they made it clear to us that although it had its own name and it was a separate partnership, it would operate as part of a national whole, and eventually it would become a national partnership. So the Law Society of Alberta was concerned about that, and they passed rules outlining national law firms. That went all the way to the Supreme Court of Canada. Regulations were struck down. Alberta Court of Appeals said it interfered with lawyers' mobility rights. Supreme Court of Canada said it interfered with lawyers' equality rights. Today, of course, 30, 35 years later, lawyers frequently practice in more than one province. They move across boundaries in their day-to-day practice, and they're also a lot more mobile than I started. You know, the norm was in the 1970s and into the 1980s that you tended to take articles at a particular law firm, you became an associate there, you became a partner there, and you stayed there for the entirety of your career. Today, people move much more frequently. There are people coming and going from law firms, and they also move provinces quite more frequently. And those are huge changes to the way that we practice. Another thing that's changed profoundly was the way that law firms seek clients, the way that they advertise. Before the Charter, about the best you could do is publish a business card-sized ad in the Yellow Pages. Today we don't even have Yellow Pages, and basically anything goes as far as advertising goes, because of course professionals, like everybody else, have freedom of expression under the Charter. We also have had, over the last 25 years, a real move to transparency at the regulatory level. Part of that means is that boards and tribunals are expected to document their policies and procedures and to make them available. So in other words, people are supposed to know what the rules are, they're supposed to know how their case will be assessed, and they're to know the reasons for assessment of their cases. And even that's a big change. I'm not here to tell personal stories, but when I started, I wanted to split my articles. I secured articles in a court, and in those days that was not as common as it is now. And I needed a break from the Law Society on the time and how much time I would spend at the law firm and when. And I went to the Credentials and Education Committee of the day. There were no standards, and they turned down the application. So we asked them, just by resolution, you know, no reasons or anything. So we asked them, well, why was that? And they said, because we don't have a standard. We don't know what to do. So we figure if we turn it down, you'll have to appeal it to the benchers. So we did appeal it to the benchers, and I had to go before all 24 of them. I was terrified. They were probably bemused, and they passed another resolution, approving it. But there was no policy. Nobody knew what the rules were. Nobody knew what the standard was to be applied. Today, of course, policies have to be based on informed decisions. The fact that we've done something the way it's been done for 25 years or 30 years or whatever it is isn't acceptable anymore. One of the most significant joint achievements of the Canadian Law Societies through the Federation was implementing national mobility. And that happened about 15 years ago. It is something that really had its its roots in the litigation in the Supreme Court of Canada that dealt with the Law Society of Alberta's attempt to outlaw national law firms. People recognized that there needed to be mobility in the legal profession. The then Combines Investigation Tribunal, now the Competition Board, published a report along the way expressing concerns about lawyer mobility. At that time, we were very much compartmentalized, and as I say, there wasn't a lot of mobility in the profession, so people would take a job in one jurisdiction. They'd normally stay in that jurisdiction for their careers. The jurisdictions didn't spend a lot of time talking to each other about what the standards were. We didn't spend much time talking to the law schools about what their curriculum looked like or anything else. You basically took it on faith that if you had a common law degree from a Canadian law school, it would probably get you qualified for articles in any of the common law jurisdictions. But once you got there and you became admitted, for the most part, you stayed there for most of your career. If you wanted to move provinces, you had to write what were called transfer examinations on local statutes. I had a lot of friends who wanted to go to British Columbia, and I learned a little bit about the transfer exam into BC, and I watched those people. They had to basically memorize all of the local BC statutes, and then they had to write a detailed examination about BC statutes. Sometimes we would make temporary appearances in other jurisdictions. Client has a certain view about what counsel they want to hire. They're not particularly interested in the provincial boundaries. If they've got their normal counsel in Quebec or Ontario, Calgary, wherever it is, and they've got something on in Saskatchewan, Manitoba, BC, they'd rather their regular lawyers be there. And so people would make temporary appearances in other jurisdictions. It was very difficult to do that. You had to get an issuance of a one-off certificate, so you'd go to the Law Society and file a whole bunch of paperwork. It required a lot of time and a lot of effort, and then you would obtain a specific certificate for that appearance. In Quebec, where I think they're still doing that today, I have a recollection only 4 or 5, maybe 10 years ago now, I needed a temporary appearance certificate to go there, and I even had to go down to the police station and get a vulnerable sector check and the letter in order to make an application for a temporary appearance in the province of Quebec. And in some places, like in Alberta, once you got all your paperwork together, then even for a temporary appearance, sometimes you had to attend for a bar admission application before a judge. So I might have a colleague coming from Manitoba who's going to co-counsel a trial with me, and the first thing we do at the outset of the trial is make sure that the lawyer's wearing a gown and pull them up and have a 2-minute perfunctory bar admission ceremony so they become a member of the Alberta Bar for the purpose of the temporary appearance. So everybody stood back and we wondered, why do we do this among common law provinces? We'd all accepted degrees from other provinces for qualification of students. We'd done that for years. There was no particular agreement that we would do that. It just was something that happened. We realized that our laws are mostly the same. The codes of professional conduct are similar. Sometimes they're shared. So eventually the decision was made that if you would qualify in one common law province for practice, then normally that would prove that you were suitable for admission in other common law provinces. And so there was an agreement put together amongst all of the provinces other than the province of Quebec, called the National Mobility Agreement, and that's what it provides. It says basically you want to move from one province to another, you're admitted in one province, you file paperwork, and the transfer is done. You don't need to take local exams or go through the suitability assessment or the fitness assessment, provided you've got a clean record in your home jurisdiction. We also made a provision for temporary appearances other than the territories. The territories have their own concerns about that, but leave the territories aside. And today we can perform legal work in any of the other provinces up to a certain number of hours per annum. It's quite a large number. And there's no formality involved at all. You're just expected to comply with the rules. Once that was implemented, then regulators began to turn their attention to other areas where we thought we could potentially be lacking in terms of protecting the public interest. And that had to do in part with the ways by which lawyers were trained, how they were assessed. So that's the admission function. We looked at the lawyer's lifelong obligation to maintain competency. Everybody has an obligation to keep current in their area of practice. We now call that continuing professional development. And we also looked at discipline standards. We had all different discipline standards across the country. So if you made a complaint against a lawyer in BC, you were treated differently than if you made a complaint even against the same lawyer in Alberta. The standards were different, time frames were different, so on. In the area of competency, ongoing competency, we had no explicit standard. Nobody gave lawyers expectations for continuing obligations or education. And so, of course, people could honor that obligation in the breach, and some of them didn't even know what they were expected to be doing. And as the regulators who discipline lawyers, we see the result of that on the other side. We know who are not honoring the rules, and it wasn't that difficult for us to understand why better standards were needed. And so in the mid-2000s, we started to formalize continuing professional development, and today lawyers are held more accountable.
Let me just interrupt because we're going to start losing a lot of people very quickly because of
Time?
classes.
Oh, okay.
Classes, so might I suggest that we, if there's the opportunity, do a quick synopsis and then go.
So I'm going to move right on, and that is to say that in 2009, we began to talk about what is the standard for law school. What should law schools teach? What should be on the curriculum? And what should be the competency of an entry-level lawyer? And we've come to an agreement over that. And so the next phase in that proposal has been to say, all right, so we have a common standard across the country. We now know what a common law degree ought to contain. We know what the entry-level competency is for a lawyer, and we've defined those just as we've defined all of the other obligations that I've mentioned, and so now we have to say, well, how are we going to assess it? So presently, a number of provinces, including Alberta, have said, well, it would be a good idea to do that nationally because we have national mobility. Anybody who gets admitted in the province of Alberta can move to the province of Ontario in about a week, and vice versa. So from the Alberta perspective, we need to ensure that people who are moving here meet our competency standard, and we don't have the ability to assess that if they've been admitted in another jurisdiction because all they need to do is file their paperwork. And so that has brought about the idea of a national admission standard. In November of 2015, the benchers in Alberta approved a motion to commit to continue to work together with the other law societies to develop a detailed plan of how we'll carry out a common national assessment program. The idea is that the system would provide consistency in how law societies would assess competencies in the national competency profile. It's mainly driven by national mobility, but it's also driven by wanting to have a system that will enhance the accountability of the assessment program. So we want to use best practices. We want to draw on the latest testing practices, resources, and tools. We also want it to be consistent. We want everybody to be treated fairly, and we want them to be treated equally. And we want it to be defensible, so if somebody comes and says, well, how are you assessing lawyers to serve the public, we are in a position to say, well, this is how we do it. It's written down. It's in a standard. This is how we came to the standard. As matters stand right now, it has gone back to the Federation of Law Societies of Canada for the development of a proposal. I'm not certain what the time frame on that is. It's not uncommon with the Federation to see them seek an early acknowledgement by law societies as to whether they want to participate. That is done for a number of reasons, one of which has to do with budget. If the majority of the law societies said, listen, we're not even interested in national assessment, then they're not going to spend the money on the Federation side to come up with a proposal for consideration by the law societies. So where we are right now is that a number of law societies have said, yeah, we are interested in national assessment. What does that program look like? Apart from the very general provisions that were provided, I know, to the Law Students Association. Nobody knows because it hasn't been developed at this time. Probably what it looks like is it looks like a series of written examinations. Some would be long-form examinations, some would be multiple choice, there would be some oral assessments, and there would be some simulation activities. The questions and the system would be national, but the answers would be directed at the jurisdiction where you're taking the test. So, you know, if you're doing your law school and your article's in Alberta, nobody's going to ask you a question that requires you to know about how people register land in Ontario, for example. The answers would be directed at the Alberta system. So that's where we're at, and that's a little bit about why we are there. I can tell you on our side, at least at the Law Society of Alberta, we're not clear. We understand that the Law Students Association here objects to the proposal, but we're not clear why. And if there are some flaws in it, then we're happy to hear them, and we will be addressing those. And as I say, this is not the last opportunity. The Federation will continue to work on a proposal, and you're as free as anybody else to engage with the Federation in a dialogue about that. And I'll make sure that you have those particulars so you know who to get a hold of to do that. But you would direct your activities at two levels. One is at us, because it doesn't happen in Alberta unless we agree it happens in Alberta, and secondly at the Federation, because chances are if there is something that's developed by the Federation, then Alberta is going to be very interested in participating, because we are very big supporters of the Federation. So I'll go that far because of the time. I'm going to assume that's why people are leaving. And I'm happy to hear from anybody today, or I'll leave my contact particulars with the association, and I'll leave them a record of who they should be talking to in the future, and I'm sure they'll be happy to hear from you as well.
Thank you very much. I appreciate that a lot of people will have other commitments at 1 o'clock, and so if you need to leave, please do so at this stage. If you have questions, though, can I ask you to actually migrate towards a microphone? We'll go about 5 minutes. I know there's another class waiting outside, so we're going to have to close things off very briefly. David, go ahead.
Well, my name is David Foster, and my objection is,
About 5 minutes.
if you look at bar exams in other places, in BC, for instance, that's where I'm from, that's where I am planning to article.
Yeah, go ahead.
But it's 2 3-hour exams, a barrister's exam and a solicitor's exam. Now, the Federation is proposing a 7-hour exam and a 5-hour exam. That is significantly more, and it's a lot harder to do a 7-hour exam than to do 2 3-hour exams, especially people with anxiety, depression, other mental illnesses. That is not necessarily going to work well for them. So I'm concerned about whether it's accessible for people to have certain mental illnesses or disabilities, whether that's even being looked at, and additionally, whether the format is actually designed to try to exclude people. In a 7-hour multiple choice exam with distraction answers, as they are described in the report, the distraction answers are meant to be as close to the correct answer as possible in order to confuse people and cause them to choose the wrong answer. That sounds like the LSAT. The LSAT is designed to exclude people. It's designed to reduce the number of applications. I don't think that someone who has spent $40,000 on a law degree, graduated from law school, gotten a job, worked in the legal profession for a year as an articling student, and in some cases being rehired, should have to play that kind of jeopardy with the national exam. And so I'm very concerned that you're gambling with people's careers, and I wonder if that's ethical.
Okay, so there's two things there, and one has to do with accessibility and designing it not to exclude some people. And we have that issue now. The way it comes up is people actually fail the CPLED course and then they appeal and say, listen, I had these problems. They deal with it after the fact. I think it's probably a great idea to talk about dealing with it before. On the other point, I will pass that forward. I don't, as I said earlier, I don't think that anybody is trying to build a design to exclude people. We're not in the business of setting people up for failure, but I understand your point, and I'll bring it to the attention of those who are involved.
Hi, my name is James Park. I'm a 3L student here. My question is kind of goes to the research behind this. I realized from reading the material and from your presentation that the large reason that there's a push for this from the Federation is to, I guess, to respond to the increased mobility of lawyers across the country. Mm-hmm. And I realize that from, I don't know, over the last couple of decades, there's been an increase, but what I'm wondering is if there's still a need. Because to me, it seems like it's a threshold issue. If there's a lot of lawyers, let's say that get called in Alberta and want to go somewhere else, like get called somewhere else but eventually want to move, then it makes sense that you might have this the standardized testing across the board. But if the overwhelming majority of lawyers end up staying in the respective province that they were called, I guess it makes me wonder if it's let's say the number is 20, I'm making this up, but let's say the number is 20% of lawyers end up moving at some point in their careers. Is that threshold enough to make the other 80% that are going to stay in their province write a national test? So I guess my question is simply if the Federation or the Alberta, if the Law Society have the numbers of mobility specifically, and if you guys have ever considered from that perspective of is there enough mobility going on to make it worth, I guess, making everyone else accommodate the few that leave versus the other way around?
We do have those numbers, and I'll take your point forward. One of the concerns with that is going to be is a lot of people, there's another very large group, which is not the people who are moving their domicile, but those who are practicing every day in different jurisdictions, the people who are on airplanes all the time.
Right.
And that, we don't have those stats. We don't monitor that.
Great.
I apologize that in light of actually the fact that there's a class scheduled for here, we're going to have to give this a close. I will work with the LSA to schedule a follow-up town hall, but let me offer something as well. If there are questions that you had that you didn't get asked, feel free to either send them to Durham and he can send them along from the LSA, or send them to my assistant and we'll make sure that they get to either Jim or the committee at the Law Society, and I'll post all of the responses, the questions and the responses. So many thanks to you for coming. Jim, thank you very much indeed for the session.